Hi, Bill Henshaw here again, and today I am revisiting the case of Ashwander versus Tennessee Valley Authority, 297 U.S. 288, one of the most important decisions of the Supreme Court, not because of the decision itself, but because of the informal quote-unquote rules of the court first fully codified as to what they will or will not hear and decide. The 7 Ashwander quote-unquote rules were on the first page of the first law course I ever took. And for good reason, because a proper understanding of how the just us system works is essential if we are to have any chance to beat the bastards at their own game and restore our Constitution. Despite the hopeful bleatings of statutory gurus about victory using the UCC, the International Court of Justice at The Hague, or even allegedly applicable statutory laws, which we should be challenging, my 4 decades of intense, passionate, and independent research of the Constitution, history, and laws of the United States have convinced me that strict adherence to the provisions of the Constitution, plus a decision by the U.S. Supreme Court, which is bound by oath to make, this is an Article III judicial court in which we have the right to present our case, is the only way out of the martial law jurisdiction hellhole there is, if one remains at all. For what it may be worth, I am 12 years all in the firm belief that there are remedies out there, and very recent events have strengthened this belief. At my hoary old age, I am from a generation which on balance was consigned to learning the old-fashioned way by actually reading books and writing essays on the subject matters at hand. To be sure, the textbooks of my times were not very good, albeit a lot better than the PC crap that infects at least all of our mandatory public education systems these days, especially in the areas of Constitution, history, and laws of the United States and comparative philosophical systems. Thus, I developed good habits which bear fruit whenever I read decisions of the courts, most particularly from the U.S. Supreme Court, because I read all of a decision, the dissents and the footnotes, the latter of which are there for a reason and are often the most important part. This is particularly true not only in 5-4 decisions, but those which were decided, in my view, against the original intent of the framers of the Constitution. Here are some examples of how valuable this technique can be used. First, from the case of Norman v. B&O Railroad, 294 U.S. 240, also known as the Gold Clause case, a dramatic decision early in the FDR Regency, which went far in enabling the circulation of Federal Reserve notes, aka evidences of debt, aka IOUs. The majority struck down a contractual agreement which mandated the payment of gold in return for the gold invested and the quote-unquote reevaluation of the quote-unquote dollar in relation to gold. Read this decision. When you do, you will see the cogent and compelling dissent of the 4 horsemen, Willis Vandivanner, James Clark McReynolds, George Sutherland, and Pierce Butler, and the Ashwander key in this decision, which as they put it was, the authority exercised by the President and Treasury in demanding all gold coin, bullion, and certificates is not now challenged. Neither is the right of the former to prescribe the weight for the standard dollar. These things we have not considered. Plainly, however, to coin money and regulate the value thereof calls for legislative action. Note that the justices have stated in their Ashwander Doctrine in Rule 3 that the court will not formulate a rule of constitutional law broader than is required by the precise facts to which it is to be applied. In other words, any decision in a case brought by a corporation, a 14th War Amendment citizen, quote-unquote, will almost certainly not be applicable to lawful de jure free white state citizens. Privileges versus rights. But it seems that you do have to prove who you are. Sound familiar? If petitioners in Norman had directly challenged the power of the president, most especially as acting as Commander-in-Chief of the Armed Forces, to define the value of dollar, I am convinced this case would have been decided differently and the course of American history changed, possibly to the extent that we would have had little, if any, involvement in World War II. Coming to United States v. Lopez, 514 U.S. 549. One of the most important decisions of the Supreme Court, and that it was the first time in 60 years, now 85 years, that the Commerce Clause powers of Congress were reduced. A major component of the unconstitutional issues which I advocate was the last to minimal effect, since recently a serious claim was advanced pursuant to the quote-unquote rights of a transgender to select its bathroom, and that taking a crap in a government-funded bathroom affects interstate commerce. No, I'm not making this up, and we are not talking about North Korea here either. Reading the concurring opinions of Justices Thomas and O'Connor is quite revealing, noting that Justice Thomas sharply noted that the court today properly concludes that the Commerce Clause does not grant Congress the authority to prohibit gun possession within 1,000 feet of a school, as it attempted to do in the Gun-Free Zone Act of 1990. Although I join the majority, I write separately to observe that our case law has drifted far from the original understanding of the Commerce Clause. In a future case, hopefully one of ours, we ought to temper the Commerce Clause jurisprudence in a manner that both makes sense of our more recent case law and is more faithful to the original understanding of that clause. And how, I might add. Goes on, we have said that Congress may regulate not only commerce among the several states, but also anything that has a substantial effect on such commerce. This test, if taken to its logical extreme, would give Congress a police power over all aspects of American life. Unfortunately, we have never come to grips with this implication of our substantive effects formula. This is a ton of truth in but 2 paragraphs and raises multiple questions about the justices' concern for being bound by this Constitution and laws created in pursuance thereof, and their motivation for clearly and unambiguously doing otherwise. A final example comes from Fleming v. Nestor, 363 U.S. 603, and from the pen of Justice William O. Douglas in dissent in this 5-4 travesty of justice, one of the many reasons he is in my personal top 10 justices, and lots of others too, but not Tricky Dick Nixon, where he opined that the 1954 law seems to me to be a classic example of a bill of attainder, which Article 1, Section 9 of the Constitution prohibits Congress from enacting. A bill of attainder is a legislative act which inflicts punishment without judicial trial. How hard of a concept is that, people? In the old days, the punishment was meted out to a creditor or rival enemy by sending him to the gallows. But as recently stated by Irving Grant, quote, by smiting a man day after day with slanderous words, by taking away his opportunity to earn a living, exactly what has been done to yours truly, you can drain the blood from his veins without scratching his skin. Today's Bill of Attainder is broader than the classic form and not so tall and sharp. There is a mental in place of physical torture, the confiscation of tomorrow's bread and butter instead of yesterday's land and gold. What is perfectly clear is that hate, fear, and prejudice play the same role today in the destruction of human rights in America that they did in England when a frenzied mob of lords, judges, bishops, and shoemakers turned the Titus Oates blacklist into a hangman's record. Hate, jealousy, and spite continue to fill the legislative attainder list, just as they did in the Irish Parliament of ex-King James. In summary, we have reviewed 3 decisions which, had they gone the other way, would have changed the course of American history. This has, to be sure, something of a nuanced look at the situation, but understanding Ashwander issues will be time well invested, as you will be far ahead of the local DAs, aka dumbasses, and even many quote-unquote judges, increasing your odds of intimidating the bastard just like I do and did in Columbia, South Carolina, and making them afraid of you, just as the framers planned it. Thank you.